Hello, everyone, and welcome to our second biweekly briefing hosted by Act for Public Health. My name is Katie Michael. My pronouns are she, her, and I'm a senior attorney at ChangeLab Solutions, which is a nonpartisan nonprofit organization that uses the tools of law and policy to advance health equity. I am really excited to be joined by Donya Khadem. And Donya, do you want to quickly introduce yourself?
Thanks, Katie. Hi, everyone. I hope folks are doing well. My name is Donya. I use she, her pronouns, and I am Equal Protection Initiative counsel at the Legal Defense Fund. We have offices in New York City, DC, and also in Atlanta. Um, the Equal Protection Initiative, for those who might not be familiar, uses litigation and also non-litigation advocacy to defend and advance the proper interpretation of the Equal Protection Clause and anti-discrimination laws to ensure that Black people and other people of color can turn to our judicial system to champion their equality. And this includes health equity work, given the importance of equal access to healthcare. So I'm really happy to be here with everyone today.
Thank you. So again, thank you for joining us for this bi-monthly briefing series that Act for Public Health is hosting to help explain and interpret the impact of recent federal actions on state and local public health practice. Act for Public Health is a group of organizations that are applying their experience and expertise in public health law and policy to help push back against attempts to block public health practitioners' ability to do their jobs. And this partnership includes ChangeLab Solutions, where I work, the Public Health Law Center, the Center for Public Health Law Research, Public Health Law Watch, and the Network for Public Health Law. We hosted our first briefing a couple of weeks ago that explored the effects of a wide range of executive actions on state and local public health practice and began the discussion about strategy for the current moment. And we encourage you all to go back and watch that recording if you weren't able to attend. For today's discussion, we're going to focus more narrowly on the executive orders and other federal actions attacking diversity, equity, inclusion, and accessibility, or DEIA, initiatives throughout the federal government, and also in some cases seeking to undermine DEIA efforts undertaken by non-federal actors, including state and local governments, nonprofits, and other private sector organizations. So we're going to start by providing a quick overview of some of these executive orders, and then we'll discuss how federal agencies have begun to respond and implement the directives and what we're seeing in the field in terms of impact to state and local public health agencies and organizations, which I'm sure many of you are experiencing and unfortunately have acute familiarity with. Donya will then describe some of the ongoing legal challenges to the executive orders, and she'll provide also some broader context from before these executive orders were issued about what Legal Defense Fund and others are doing to safeguard our rights under the Equal Protection Clause. In line with the last briefing, we'll end by discussing strategy for the current moment and how public health practitioners might think about acting together to respond. And as we go through this content, our partner Q from the Network for Public Health Law will be sharing resources in the chat available from Act for Public Health and many other wonderful organizations. I also just want to quickly acknowledge that while we're focusing narrowly today on federal executive actions attacking DEIA, the president's actions affecting LGBTQ plus communities also hinder DEIA goals and activities. And to learn more about that, we encourage you to read the Act for Public Health FAQ document that focuses on executive orders affecting LGBTQ plus communities, and also to tune into our next briefing in a couple of weeks that will focus on that topic. I also want to note that there are things happening at the state level, both state level executive actions and legislation that are limiting DEIA efforts by government agencies and sometimes private sector agencies. And those are outside of the scope of our discussion today. But if you look at our FAQ document, there are some links to trackers where you can check out some of the stuff that's happening at the state level. And then finally, I just need to note quickly that although Donya and I are lawyers, we're not your lawyers. The information we're providing in this briefing does not constitute legal advice or legal representation. And for legal advice, participants should always consult a lawyer who's licensed to practice in their state. And with that, I will pass it over to Donya.
All right, so I think it would be helpful to first start by giving a quick overview of what diversity, equity, inclusion, and accessibility efforts are. So I know a lot of folks on this call are probably familiar, but still it can be important. And I'll note that DEI or DEIA is how these efforts are typically referred to, but at least at the Legal Defense Fund, we really like saying all the words out fully because we think that it's really important to remember, what that this is about fundamental American principles, such as accessibility, such as equity. So diversity, equity, inclusion, and accessibility serve the purpose of ensuring that everyone has equal opportunities and access to opportunities, regardless of social and demographic characteristics such as race, ethnicity, sexual orientation, gender identity, disability, and religion. These efforts can be called many things and named different things. Diversity, equity, inclusion, and accessibility efforts are not racial quotas or racial preferences. We think of diversity, equity, inclusion, and accessibility efforts as race-neutral activities. Race-conscious activities we normally consider falling under a different bucket. So since taking office, President Trump has issued dozens of executive orders and directives that stretch the bounds of executive power and the law. These executive actions are by design meant to create chaos and create fear. A lot of these anti-equity efforts are not surprising, given the work of opponents of civil rights in the years leading up to President Trump's second administration. So what I'm referring to most prominently, though this is not the only case that has weaponized or chipped away at civil rights protections, is the SFFA, Students for Fair Admissions versus Harvard case. That is a decision that came down in 2023. There, the Supreme Court struck down Harvard and UNC's race-conscious admissions policies as unconstitutional. The reasoning is really important as we get into this conversation about the history that led to where we are today. The court in that case said that the policies, however well-intentioned and implemented in good faith, failed to pass constitutional muster under strict scrutiny because they were not narrowly tailored to a compelling government interest. When it did that, the court undermined almost 5 decades of civil rights precedent by applying a radical and much more stringent version of strict scrutiny than it had applied in the past. Still, the court's decision really is limited to the consideration of race as like a tip in college admissions as conducted by Harvard and UNC for the pursuit of educational benefits of diversity. The court in its decision explicitly noted that its ruling does not address the legality of race-conscious admissions policies at other kinds of universities, such as military academies, and it also has no direct impact on things like race-neutral policies. This is all really important because nonetheless, opponents of civil rights, including this administration, have reframed what cases like SFFA stand for and are using it to target diversity, equity, inclusion, and accessibility efforts in ways that will and already have impacted efforts to advance health equity. So as Katie mentioned, there are a lot of anti-equity executive orders and a lot of executive orders that could and have impacted health equity work, but we're going to focus on 2. The first is ending radical and wasteful government DEI programs and preferencing, which is formally titled Executive Order 14151. And then the second is an executive order titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which is numbered 14173. These work together. I'm going to refer to them as the anti-equity executive orders. So the anti-equity executive orders terminate equity-related grants and contracts and prohibit federal contractors and grantees from operating programs that promote diversity, equity, inclusion, and accessibility that violate any applicable federal anti-discrimination laws. That part is really important because advocates for civil rights have long understood relevant federal anti-discrimination laws to mean one thing, but as I said earlier, there have been a lot of misinterpretations of the law. Contractors under these executive orders are required to certify compliance with these conditions, and the consequence of improper certification could even include False Claims Act liability. And for folks that aren't familiar with False Claims Act cases, they're pretty scary because the government can bring them, but so can any third party. And they result in treble damages, so like multiple times the amount of a grant, for example. So it's a pretty serious liability, which can be really chilling for patients trying to navigate these executive orders. Again, the president is cloaking himself in some sort of defender of equal opportunity cloak, when in reality, what him and his administration are doing is just taking a stance on a viewpoint that they disagree with. They've decided that these efforts are bad for America when in reality they are not. And that is really the motivating factor here. So that is a little bit of an overview of the orders at issue.
Thanks, Donya. So I was going to dive in a little bit to some of the impacts to public health that we are seeing as a result or in response to these recent executive actions. And before doing that, I just wanted to reiterate Donya's point that diversity, equity, inclusion, and accessibility is fundamentally about ensuring equal opportunity for all, and just to underscore that goal is really core to public health, that this is really so closely connected to core public health goals. In recent years, especially, public health practitioners across the political spectrum have recognized that improving health at the population level requires ensuring that everyone has a fair and just opportunity to be as healthy as possible. And DEIA can support that goal in public health, broadly speaking, in so many ways. So, for example, DEIA programs undertaken by public health agencies and organizations can ensure that the public health workforce is representative of and equipped to address the needs of diverse populations. These efforts can help to ensure diverse representation in research, creating data that we need to address public health. They can ensure equitable funding opportunities, training for healthcare providers to effectively treat patients of all backgrounds. And then looking more broadly, diversity, equity, inclusion, accessibility, and other just anti-discrimination laws, broadly speaking, can affect can affect all of the social determinants of health. So ensuring equal access to quality education, safe, stable, affordable housing, good jobs, and more. And so when we talk about attacking diversity, equity, inclusion, and accessibility, we're really talking about undermining all of those things that support public health, broadly speaking. And so now looking more closely at how federal agencies have begun to implement the executive orders and impacts, I think at a really high level, and I'm sure this is going to miss nuances in certain things, but I'd say significant impacts fall into three buckets, and they're interrelated, and they include loss of jobs, loss of funding, and loss of data and information that we need to address public health. So for public health practitioners working in federal agencies, we know that there have been really significant reductions in force at HHS and agencies within HHS like CDC, and that those agencies have been directed to dismantle offices and programs that work on something that could be potentially considered related to diversity, equity, inclusion, and accessibility. We also know that federal agencies have been sending letters to grantees to terminate grants that are equity related or that support equity related work conducted by state and local governments, state and local health departments. And then we also know that National Institutes of Health has sent letters to academic researchers to end funding for research that could be considered equity related. And then for non-federal public health agencies and organizations that receive federal funding, we're also hearing from the field, and I'm sure many of you are experiencing this directly, that agencies are significantly changing or reorganizing offices that do equity-related work. They ceasing equity-related research and programs, either because they're losing funding or because of fear of federal enforcement and other negative outcomes and more. And so just to get back to what Donya was saying earlier, these executive orders really are designed to sow confusion and fear, and people are really scrambling to try to figure out what it is they need to do to comply. And part of that confusion stems from the fact that the executive orders themselves don't specifically define diversity, equity, inclusion, and accessibility, or what types of conduct they address. And there's no generally accepted or legal definition of DEIA. And so getting to the strategy that we'll talk more about later on, one thing that I know Act for Public Health has really been emphasizing is to resist preemptive overcompliance. And I know that is hard, and it's a fine line because the risk of federal enforcement and negative outcomes is real. And so it's really about talking to your legal counsel and figuring out the best path forward in light of risk tolerance, available resources, and then also figuring out if the activity that you're considering halting is actually supported by our federal civil rights laws and other constitutional protections for free speech and things like that. In terms of other strategies for pushing back, of course, one way is to file a lawsuit in federal court. And I know that that is not something that everyone can do, but it is one strategy. And so I wanted to pass it to Donya to talk about some of the lawsuits that LDF is involved in.
Yeah, so as Katie said, one of the things that's been most concerning and most harmful about these executive orders is the lack of any kind of clear guidance about the conduct that is prohibited. This is especially concerning given the sort of liability at stake. I had mentioned earlier, False Claims Act liability, but there's also just the reality that so many organizations that receive federal funds really rely on them to operate. That's definitely the case for smaller organizations that might completely cease to exist without federal funding, but it also impacts, much larger organizations. So one of, the Constitution's protections is under the Fifth Amendment. It's prohibitions against unconstitutional vagueness in violation of due process. So basically, the idea, just to put it super simply, is that it typically comes up in the criminal context, but is also relevant in the civil context. And it's, if there's a law and I'm going to be punished for violating it, I need to know what is and isn't required by the law. And in these executive orders, diversity isn't defined, equity isn't defined, inclusion, accessibility, lawful and unlawful aren't clear. And you might be thinking, oh, that's obvious because we have cases and we have rules. But given the sort of differences in interpretation, it's not that obvious. Equity related isn't defined, right? Does that mean every single grant or contract provided by the federal government that advances opportunity? Does it need to be racial equity? In some of the anti-gender executive orders that we aren't focusing on today, but I know is the topic of later briefings, they suffer from similar vagueness concerns. And so seeing this and also recognizing that organizations have a First Amendment protected right to advocate for diversity, to advocate for equity, inclusion, and accessibility. A lot of civil rights organizations on the national but also local level have started to bring lawsuits really from like the beginning of the administration, challenging these anti-equity executive orders as violating the Fifth and First Amendments to the Constitution, and then also violating things like separation of powers, arguing that these actions exceed the president's powers because some of the grants and contracts at issue are actually authorized by Congress. Some of the cases bring Administrative Procedure Act challenges. And we don't have to get into the technical parts of the claims, but I think what's important to know is that many organizations, including the Legal Defense Fund, the Lawyers Committee, Democracy Forward, AAJC, and others have actively been bringing cases on behalf of organizations similar to a lot of the organizations on this call today, and defending their rights to be able to, use their federal funding to advance these kinds of missions. In the First Amendment space, the claims are chilling. So basically, the idea that these executive orders just all seeing them and seeing how some of the guidances have been coming out have a chilling effect. And that's what Katie was talking with, trying not to proactively overcorrect in a way that is not actually helpful or required by the law. That's a very common thing that happens. And that's what chilling is. It's the idea that, in fear of maybe losing federal funding, organizations are going to take away programs or fire staff or change the names or the way they do things. Some of the First Amendment claims also include viewpoint discrimination. So it's putting it in a very, everyday example. It's just the president does not believe that diversity, equity, inclusion, and accessibility are American values. And so he is discriminating against organizations that frame it that way, or discriminating against organizations in the issuance of funding that advocate for, for remediating systemic racism, or in the health equity context, organizations that argue or advocate for research that helps advance, Black maternal health, for example, and making it specific to certain demographics that have had harder times given systemic inequities accessing sufficient health care. So I think those are kind of the core claims. And there are three sort of big cases, though there are many, and I know that I'm already talking a lot and I could go on, and I can tell you all where you can look at more of them. But the Lawyers Committee has a case where they represent Chicago Women in Trades. That's a case in the Northern District of Illinois. They were able to get an injunction against some parts of the anti-equity orders against the Department of Labor, which is where they get most of their federal funds from. In our case, it's in the District of DC. So these are all federal district court cases. And we are currently working on amending and supplementing our complaint after a preliminary injunction that we were not successful on. We have had like more and more examples of unconstitutional actions taken against our clients. That's the National Urban League versus Trump case. And so we feel like an amendment will be helpful. And basically, our claims, in addition to all of the things I described just now, in general, also include equal protection claims. That's kind of what's unique about our lawsuit. The equal protection claims, just to summarize them, are basically that there is intentional discrimination going on here because the three clients in our litigation, the National Urban League, the National Fair Housing Association, and the AIDS Foundation of Chicago, all work primarily to support marginalized communities. And so their programs that they receive federal funding for impact, for example, Black communities, transgender communities, queer communities, other people of color. Um, and that is like their service community. So when you take away that funding, it's going to have a disproportionate impact on certain communities. So that's kind of the gist of our equal protection claims. And then in the District of Maryland, there's also currently an appeal to the Fourth Circuit of a successful grant of a preliminary injunction in the National Diversity Officers case. So these are all cases that are at like different stages. There's a lot to be tracking, but the clearinghouse, it's Michigan Law's civil rights clearinghouse, is a really great resource. If you just want to like, literally, you can go and click on like Trump related litigation and then filter for these kinds of issues and be following on a, day-to-day basis, even if you're interested, what's been happening with the cases.
I know that somehow we are already getting close to the half-hour mark. And so I just wanted to quickly make sure we touch on one point, which is we have been talking about litigation as one strategy to push back against these executive orders. But Donya, I know you and I were talking about collecting stories of impact more broadly and sharing them as a way of shifting public opinion about what DEIA is. And so wondering if you want to share more about that and how like stories of impact are helping your work and also being used at LDF.
So litigation is obviously important, but especially given the state of courts right now, non-litigation advocacy is just as important, and can really be impactful. And one of the ways that the Legal Defense Fund, but also so many of our partner organizations are leveraging non-litigation is by seeking out stories from organizations, from individuals that have been directly impacted by the executive orders. And that doesn't need to be a termination or suspension of a grant or contract, though that's obviously, those stories are welcomed. It can also just be explanations about the programs that are funded, the research, why it matters that this research continues, who is being impacted, the consequences of these federal funds and contracts being cut, the consequences of organizations no longer being able to advocate for these things. And I think given that so many folks on this call work in health equity, that's a really powerful type of story to share because what we've noticed is that diversity, equity, inclusion, and accessibility activities are not actually understood as well as you might think in the public sphere. I think there's a lot of confusion around whether they are racial preferences or quotas instead of, merit advancing and an opportunity to open doors for folks that have the qualifications and opening opportunities for that's like in labor and health. It could be making sure that doctors have the information they need to provide culturally competent care, things like that. So when you have stories like that, it can be really valuable. We can share them in op-eds, we can share them in webinars like this at coalition meetings, through news and communication. So we really welcome those. And I'm happy to share my email in the chat because LDF is always open to talking to folks about what's happening.
Thanks. And in our last minute here together, just want to like underscore one point, which is that diversity, equity, inclusion, and accessibility are still lawful. There is no constitutionally sound law adopted by Congress and no court that has established that diversity, equity, inclusion, and accessibility, broadly speaking, are illegal. ChangeLab Solutions is working on some more comprehensive resources to help public health practitioners navigate decisions about what types of programs and activities they can pursue and how those might fare in courts. And then also just want to note that if you are registered for this briefing series, you will receive a follow-up email with the recording, with links to resources that were shared here today, and you will be notified about our next briefing in June in a couple of weeks that will focus on executive orders affecting LGBTQ+ communities. So thank you so much for joining, and we'll see you at the next briefing.